Further hearing in the appeal Shanks against Unilever Plc is others.
Yes.
My Lady, my Lords, we were in the middle of discussing some of the criticisms made of the hearing officer's decision, which is at tab 19 of bundle 2, and the relevant passage is at page E418. The point that I got to was this. It was accepted by Professor Shanks, we say rightly in the Court of Appeal, that it was in principle appropriate to take account of the group profitability and turnover, and that that was a relevant factor in considering benefit in context. That's in paragraph 58 of the Court of Appeal's decision. The criticism that was advanced was that because Unilever had failed to show that there were other patents of greater benefit, it was therefore not able to make a relevant comparison. And to address that argument, can I just show you what the underlying evidence was that the hearing officer had to base his decision on, to show you what the attempt was, what the purpose of it was, and why the criticism that is made of it, and what would be required if you would hold that that was something that was necessary, would be itself an unreasonable burden. For this you will need volume 6, tab 42. This, and the electronic reference is E1374 and following. This was evidence from Mr. Mulder of Unilever, who was the Vice President of Patents, to which the hearing officer referred. And what he was seeking to do, as many of the witnesses were, and the statute requires, was to place the benefit that Unilever obtained into an appropriate context. And he did that in a number of ways, looking at the patent position. At paragraph 9, just to, as a preliminary, he noted that the costs of running Unilever's patenting activities were themselves about 29 million euros per annum at the time he made his statement, and in 1998 they were about 23 million. And that just gives you a flavour of the context, because the benefit that is said to be outstanding is a benefit which, at least in the context of Unilever, would barely have paid for a single year of its patent department. Then coming on to the points that the hearing officer specifically referred to, first of all, he referred to Unilever's exploitation of its patents, and he noted a number of products which were particularly important, and he mentions those in paragraph 10 and attempts to make some evaluation. And the hearing officer did find that material of assistance, and he refers to that specifically in paragraph 219 of his decision. And that, we respectfully submit, is useful contextual material, albeit general, trying to put the benefit from these patents into the context that is the appropriate context. Third, in paragraph 14, that's at page E1377, Mr. Mulder puts forward a document which was not prepared for the case. It was actually a document which is confidential, but it was an attempt to do evaluation of patents generally within Unilever. And there's a metrics September 1998 document. It's actually in the bundles if you want to look at it, but I'm not going to invite you to turn it up. It's at E2998 in tab 63. And what he does is he looks at the various patent families in various aspects of the business, and in paragraph 15 reaches a conclusion that the average patent of each patent family relates to some 8.85 million of sales in that analysis. And he says, in a sense perfectly fairly, it's not a precise calculation, but it is something that gives a flavour of the context. And it is true that the hearing officer did not find this of great assistance. He didn't find it of no assistance. And you may say, well, actually it is of some assistance, but not great, because we're talking here about sales. But nonetheless, what it does is it gives a flavour of what might be called the average expected return in terms of sales, and one can do a very rough and ready thinking about a likely margin with respect to patents more generally. And against that background, an annual return of the kind that we're concerned with in this case would actually be run-of-the-mill. Now, what my learned friend says is, well, what we need to do was to do a detailed evaluation of each of the patents to work out, in a sense, a la Kelly, exactly what the value of the patents was that was attributed, so that the comparative exercise could be undertaken with respect to the patent in issue. And the submission is that unless that's done properly, because we're thereby disadvantaged in being able to place it into context. And we respectfully say that that would be a very undesirable thing for this court to hold, because effectively what it would be saying is that in order for an undertaking to defend itself from in a claim of this kind, not only would there have to be a detailed evaluation with respect to the patent in issue, which in some cases, as one sees in Kelly, is hard enough, there would also need to be an evaluation in relation to all of the other patents in issue, and possibly all sorts of other aspects of the business where patents were more or less important. And we respectfully submit that that really is not something that should be encouraged. What should be encouraged in a case of this kind is for the parties to put in sensible evidence that at an appropriate level of generality gives the tribunal a context sufficient to make a finding as to whether or not, against that context, the patent in question is of outstanding benefit. And if I may just add a coda to that point, which is that if one thinks about the application of the law as amended by the 2004 Act, so that one's not just concerned with the benefit from the patent, but one's concerned with the benefit from the invention, which potentially might extend beyond the life of the patent, or might be more general because of supplementary protection in the context of the pharmaceutical industry, of regulatory protection, and so forth. One can envisage an inquiry being a very, very substantial one, forcing a burden on on undertakings, including a burden in relation to disclosure, confidentiality of evidence, documentary material from around the world, because if one is doing this analysis on the basis of worldwide revenues for the patent in question, one also then has to do the exercise on the basis of worldwide revenues for the other patents. And then the logic of the argument says, well, actually, what you also then need to do is to explore the precise circumstances in which the relevant inventions there were made, whether they were made with, to use my learned friend's phrase, 1 or 1,000 people, what the notional rate of return was with respect to those. Doubtless, there are some accountants, forensic accountants, who would jump with joy at the prospect of what might be called an additional income stream at that juncture. But we respectfully submit that that is not something that this court should, without considerable hesitation, foist upon both industry and, we would respectfully submit, employees. Because as soon as one does that, employees then have a huge burden of addressing those issues themselves. This is a jurisdiction which was intended to operate in the Patent Office primarily, albeit that there can be transfer to the court. If one turns this whole issue into effectively a state trial on every occasion, requiring employers to turn out every aspect of their business and employees then to challenge that, actually the position becomes worse for both sides in this kind of context. And it is against that background that we respectfully submit that the hearing officer was entitled to take the totality of the evidence that he had before him and to consider, on the basis of the totality of the evidence of context, whether against that contextual background this patent had delivered an outstanding benefit. So if I may then turn back to the decision and take the matter...
So just before you leave this, Mr.
Yes.
McDonough, may I ask just two questions? First of all, is Mr. Mulder saying that really all of your products are protected in one way or another by patents? I mean, there's no... I understand your submission about complexity of breakdown, but he's talking here about patent families, which may themselves be quite substantial.
Indeed.
Is he indicating that all of the product lines? Or
no, I don't think one can take that from the evidence, and that was not gone into in great
yes.
detail. In some cases, it may be that all are protected. In some cases, there may be one range of products that is protected by patents and other products that are not.
I see.
If one thinks about the detergent sector and washing sector, there are actually lots of patents in that area on the precise chemistry and the technology and so forth. That may not be the case in other areas. You can see that there's going to be a spread. But my point is a slightly more general one, which is that for the purpose of this jurisdiction, what the tribunal is charged with is placing the benefit that has been obtained into context. And we say that material of this kind actually does provide a helpful context, and that one shouldn't be criticised for not providing the level of detail of context that my learned friend says should be provided.
This doesn't give... The other question I wanted to ask you is this doesn't give any idea of profitability, does it?
No, and there is an issue in relation to that, and one of the reasons why the hearing officer didn't find this of great assistance is because the exercise wasn't one that went through each of the ranges, saying, oh, well, what is the profitability of each of the ranges? But what it does is it gives the tribunal a flavour of the scale with which one is concerned. And if one needs to step back a little bit in relation to profitability. If one looks at the figures of profitability of Unilever taken as a whole, it's actually, in the relevant periods, it was a substantially profitable undertaking. So one would assume that there was considerable profitability. How one apportions that over the individual ranges is doubtless a matter of great complexity, and we would respectfully submit that that shouldn't be something that has to be gone into in great detail on a application of this kind.
Thank you.
So that's what I would want to say about that aspect of context. Coming back to the decision, as I said, Dr. Mulder gave, in paragraph 219, Dr. Mulder's evidence was found helpful. And in paragraph 220, he analysed the issue of rate of return. We say the rate of return is a factor that one can take legitimately into account, but it's not the dominant factor. My learned friend wants to turn it really into the dominant factor. And it is, in a sense, right that if one's looking at patents that have a licensing exploitation, it may well be the rate of return is a significant one. But it doesn't mean that the benefit that one gets from that is a substantial one, let alone an outstanding one. The next point in paragraph 221, on the point of another comparison that Mr. Emmanuel was seeking to make to put matters into context from that perspective, but in our respectful submission, the hearing officer was right to reject that as not being of particular importance. And one of the reasons why that is the case is because it might be said that that is in some senses discounted already, because if one is discounting the costs of making the invention, that will come into the evaluation if one's thinking about the one or the 1,000 in any event. So in our respectful submission, he was right not to regard that as a critical feature. So what the hearing officer then did, and we respectfully submit entirely justifiably, was to base his decision on the totality of the evidence, and the evidence was quite extensive, both on the financial matters. I've shown you the matters relating to patenting, and the matters relating to what the right scale is in this context. And he reached a decision which, in our respectful submission, is a perfectly reasonable decision in the light of all of that material. May I come back then to a point that my Lord Kitchen raised in relation to, is it right to look at some smaller entity? That was addressed in a number of ways by the hearing officer. First, and in connection with that point, the hearing officer did analyse the role of CRF and CRL in some detail, and it was based on quite detailed evidence, and I'll show your lordships and your ladyships the material just in very general terms. There was evidence from Professor Birch as to the structure. That's recorded in paragraph 28. There was also evidence upon which the hearing officer based the conclusion relating to Colworth in quite extensive evidence from Mr. Samuel. And Mr. Samuel's evidence is of some relevance, because Mr. Samuel not only deals with the matter of significance on a, what might be called group-wide basis, but also deals with the matter of significance on a CRL basis. And you will find that in the same bundle we were looking at, that's bundle 6, but at tab 46, and the electronic reference is E1544. Mr. Samuel was Unilever UK's National Financial Director.
Mr. Alexander, just before you go on, it says it's confidential.
Yes, and I'm going to try not to refer to openly to anything that is...
Well, you can ask us to read specific paragraphs.
If I can ask you to read parts. In fact, what I was not going to do was invite you to read it sitting here, but just draw your attention, if I may, just to save a little time, to the key points, so that you can see that there was a good deal of evidence relating to this matter, which the hearing officer, we respectfully submit, rightly summarised. So if I can just draw attention to the topics with which this witness dealt. He explained at paragraph 14 onwards CRL and its role within the Unilever Group. He explained the legal structure in some detail. He explained the role of CRL as an entity and the manner in which the accounts of Unilever and CRL were dealt with. He then went on, I'm on in paragraph 33, just looking at the headings, to deal with the management structure of Unilever and the various sub-entities. He dealt with the medical products and medical diagnostic products and their role, contrasting with the position that this was regarded as completely outside Unilever's remit, where he explained that. He went into the management accounts of Unilever at paragraph 55, and then he explained, just to answer, I think, a point from my Lord Kitchen, in detail the central research and development within Unilever, the fact that it was centrally financed and budgeted, that there was a central engineering and research fund which funded the work, including the work with which we're concerned here, at CREF. He discussed the precise issue of the funding of the biosensors section at Colworth, explained the patenting costs, took a considerable period to explain the context of an income of £23 million in the context of Unilever, and explained, again, trying to put the matter into, this time, a commercial context rather than a patent context, that it was not a sum which spread over a long period was material at a management group level. Of course, my learned friend makes the point that a loss identified in a single year, £15 million, may be regarded as significant. It doesn't follow that a benefit spread over a considerable period of this kind would be regarded as significant in this context. He deals then with the CREF policy documents and what was budgeted for and the way in which all of these, the budgeting was done. He deals with the issue that was perhaps one of the issues that perhaps lay behind my Lord Kitchen's question in paragraph 80 in relation to CRL and the fact that it was not charged with making money or even trading, and that was why it was artificial to take it as a company, and says that even if one does that, it's not material in the context of CRL's business. And he annexes to that statement, and here there probably is more confidentiality, so I'll just invite you to look at that. The turnover figures were at page E1565 in the electronic bundle, combined turnover and profit for Unilever, and some other important background matter, namely the research and development expenditure of the Unilever Group, which in those years you see was a very substantial amount. Then the approximate expenditure of the central research funds, again, which you see was a very substantial amount. If one, as it were, spreads the benefit from the patent over the expenditure of the research function, one actually sees that it is very difficult to see that it would make a significant difference to that function. And of course, for many years, it made no difference at all because there was no money at all received. So we respectfully submit that a hearing officer or tribunal charged with the duty of identifying what a benefit is, placing the benefit into an appropriate context, is properly entitled to give due weight to material of this kind, which illustrates the nature and size, one might say, of the benefit in the context of the nature and size of the undertaking. May I then come back very briefly on a few further points. First of all, it is said that Mr. Emanuel's evidence was accepted. One has to look at that with a little bit of qualification. First of all, Dr. Osborne, who was looking at matters from a perspective, if you just glance at their respective reports, they came at things from a very different angle. Dr. Osborne was a former research scientist who worked in industry, had experience with AstraZeneca and so forth. So for him, he was looking at it from the perspective of fairly substantial undertakings. Mr. Emanuel was someone for whom a return of £50,000 from a licensing program would potentially be regarded as significant. It's true he was more focused on licensing because he was a licensing specialist in that sense. But Dr. Osborne's evidence was accepted by the hearing officer in significant respects. His evidence was accepted in relation to the basic financial comparison at the decision paragraph 202. The approach of Mr. Emanuel that you need to look at what would be relevant for a small company was not accepted. Mr. Emanuel's approach on a whole side issue in this case, with which fortunately you haven't been troubled, on the valuation in the context of the Unipath sale was not accepted, and Dr. Osborne's rather careful analysis of that was preferred. In contrast, Mr. Emanuel's approach to the valuation of the Birch patents, which was another issue in relation to discounting, was preferred to Dr. Osborne's on the basis of Mr. Emanuel's more detailed examination of the particular licensing issues in question. So we respectfully submit that you do need to operate a little bit of caution with saying, oh, well, Mr. Emanuel was accepted on all points. He wasn't any more than Professor Shanks was accepted on all points. So the hearing officer had contemporary records, factual, technical, and commercial witnesses from Unilever, 3 experts putting the technical benefit and the financial and what might be called IP benefit, very broad terms, into context. And against that background, he made an evaluation which we submit was right. We do not go so far, or we do not need to go so far, as to say that it would have been impossible for someone to reach a different conclusion. But that is not the test for appellate review. And we would respectfully submit that this court, as many others, has set good examples to others of what might be called appellate modesty. And you should not feel that in exercising appellate modesty in this case, you are doing some great injustice or leaving some great injustice uncorrected. Let us remember and step back a little bit from what is going on here and the context. A modest amount of work led to a patent of questionable validity, and when I say questionable validity, it's not just me saying that. Unilever was questioning the validity themselves at the time, and there was an issue in relation to that with the licensees questioning it, which had no benefit to Unilever in its core business ultimately, which had no return at all for 10 years and was therefore a pure cost to Unilever for that period, and achieved towards the end of its life some residual royalties as a result of Unilever in part exercising its very considerable muscle, which, if one looks at them from the perspective of patent litigation, amounted to effectively the amount of the cost of modern US patent proceedings, in each of them, which in no year in which they were received had a more than 1% impact on Unilever's overall profitability. Yet what is said on the other side is that it would be an injustice if you were not to say that Professor Shanks should nonetheless be entitled to an award which would make a significant impact on him. That would be, in a sense, not to treat like with like, actually to create in some way a disparity on the fundamental threshold question, where an individual makes something which actually doesn't create a significant benefit, but nonetheless comes along and says, I want to have a substantial chunk of that. Can I then come back, before turning to fair share, very briefly on 2 points on undertaking. We respectfully submit that it is right, and indeed it was common ground before the Court of Appeal to look at the profits and turnover of the Unilever group, that is clearly correct on whatever view one takes of the employer's undertaking. Yesterday, I was asked about whether Mr. Justice Arnold was right, and I think the answer I gave was probably insufficiently nuanced. The position is this. What we submit Mr. Justice Arnold was getting at was a point akin to the point that I was making yesterday, which is that if you use the deeming provisions to deem the benefit to be obtained by the by the employer, there would be an asymmetry in then leaving out of account the fact that it was the main group that was exploiting the benefit in making the evaluation required under Section 40. It is true, one might say, that it doesn't follow as a matter of pure logic, but it does, we respectfully submit, say that it follows as a matter of commercial logic. And the reason one might say this is because if one thinks about the employer's undertaking, what is the employer's undertaking? It is a joint undertaking with Unilever Group. That's the whole point of it. And so to say, well, actually what I'm going to do is completely turn a blind eye to the fact that this is a company which is engaged, indeed embedded in Unilever to produce the central function and benefit, we respectfully submit that that would be to take the anti-avoidance provision and turn it into a provision that undermined the ability to do that which Section 40 requires one to do.
Then, Mr. Alexander, am I understanding you correctly that you're submitting, at least in this part of your argument, that one must treat like with like and the deeming must be applied to everything?
Yes, or at least, even if one doesn't think about this in terms of deeming, if one thinks about taking into account, among other things, the size and nature of the employer's undertaking, what the argument that is put against us suggests is that the effect of the deeming provision is to preclude the tribunal from taking into account the fact that the actual employer as a legal entity is part of a corporate group, that it is engaged in an undertaking with the corporate group, and that in a very real sense the group activities are the employer's undertaking. Because what that would do is effectively use the deeming provision artificially to cut out from Section 40 a factor that one might say that the deeming provision was particularly key to ensure should be taken into account. And so we respectfully submit that even if it's not a matter of pure logic, it is a matter of what might be called statutory logic or a common sense approach. And it goes a little bit further than that. What you cannot do is to say, and indeed it is not said, that you cannot take account, or the hearing officer was wrong to take account, of the profitability and turnover of the Unilever Group. So we respectfully submit that if one looks at it in that way, which is a perfectly reasonable way to look at it, the position and approach that the hearing officer took was correct, and that there's no basis for looking at things more narrowly. Insofar as one wants to do that, the evidence is actually to the contrary, insofar as one looks at CRL. So can I turn to fair share? And may I deal with that briefly? The hearing officer took a range of factors into account, which we submit he was entitled to take into account. The only matter that he left out of account, which we respectfully submit should have been taken into account, was taken into account by Mr. Justice Arnold, and the reason for it is this. If one thinks about that set of sections as saying, well, what we want to do is to get some sense of what the employer brought to the table. In the context of a patent that is exploited by licensing, the employer's formidable deal-closing power is something that one might say one doesn't want to leave out of account in deciding what the employer has brought to the table. just as one wouldn't leave out of account in the context of a product that was exploited by sales, the formidable sales force of the employer. It is in part that delivers the benefit. So to leave that out of account, we say, was a matter that was rightly corrected. May I then turn to the second aspect of matters that is said that should lead to a larger figure.
It was said against you that paragraph 207 of the hearing officer's decision was evidence that he did take it into account, and I think I'd welcome your response.
I'm sorry, I thought I'd covered that yesterday, but let me cover it again. 207, no, that's actually dealing with a completely different point. What the hearing officer there was dealing with was the ability of an employee to leverage the fact that they were an employee in a larger company, with the result that the benefit that the company would get from the individual's work would be expected to be bigger than it would be in a small company, because they were, if one thinks about a manufacturing context which has already got an established sales force, for example, if an employee makes an invention, they're doing that in the context of a company with an established sales force. And therefore, that is something that, what you can't say is, that is a reason for looking at the figure completely in the abstract. What you need to do is to look at a figure in the context of the undertaking. There's a different point that we submitted and which found appeal with Mr. Justice Arnold, which was that Unilever had formidable deal closing power as a result of its position when it was negotiating with licensees, and that's a very different matter from the employee-employer relationship, and it was right to take that into account. The incidental benefit of that was that there was somewhat greater equalization with respect to the position in Kelly. And one might say that that is not such a bad benefit on the basis that in some ways one of the things that the hearing officer held on this aspect was that neither party had done a great deal. So whereas in contrast with Kelly, both sides had done a great deal, and so there actually is some basic justification for considering that comparable. In our respectful submission, there are other reasons why you should be cautious on this. You were referred to evidence from Dr. Osborne on the universities / commercial comparisons, and I'm not going to go to that now because you can read it for yourselves, but I would commend tab 43, that's bundle 6, from pages E1426 on paragraph 187, that's section 8, on revenue sharing and employee expectations in its entirety. He does an analysis in relation to that. You've been given a CEPA article which also which is referred to there and refers to some of the provisions in other European countries. One thing that is actually quite striking about that towards the conclusion is that what's said is that in France, Sweden and the United Kingdom, inventors have received very high awards, up to £600,000 in France, SEK, Swedish krona, 5 million, I think that's about £500,000 in Sweden, and of course 1.5 million in aggregate in the United Kingdom. So these are regarded by this academic as very high. And if one looks at things in percentage terms as well, in terms of there was a Japanese settlement that was ultimately reached in relation to one of the most valuable inventions, the blue LEDs, which is referred to in Dr. Osborne's report, and that resulted in a settlement that was ultimately for somewhat less than 1%. Now, Dr. Osborne provided a set of reasons, some of which were factual, some of which were his view, as to why there was a rationale for a distinction between academic inventors and commercial contexts. Very briefly, academics generally not employed to invent. In fact, one of the points that's sometimes made is that you need to provide them with special encouragement to do that, whereas in the case of a commercial inventor, that is the core of their job. As I said yesterday, the legislative context, the background is different. Context of the university schemes may be quite different. The sums that one is talking about may be quite different. Similarly with UK public sector research organisations. And the sums is not a point that you should overlook. If one's dealing with commercial products, particularly in some of the high-tech industries, one's dealing with things that may return, if they're a blockbuster, billions a year worldwide as a very direct result of patented inventions. And if one takes percentage rates and just looks at this in terms of percentages, one then finds a very undesirable situation that is created, that although it's true that those named inventors absolutely cash in beyond the bounds of avarice, you create a whole set of new difficulties internally in organizations, because then you might say, well, it actually creates a particular incentive to be named on a patent. There's a whole set of inventorship disputes that then emerge in many jurisdictions. If one makes the stakes as high as tens of millions, billions of dollars, one is creating potential problems, may upset other issues internally. And of course, the approach that is urged upon this court would put the United Kingdom very much out of kilter with what is done elsewhere. So we respectfully submit that if guidance needs to be given, it should be given with a realistic eye to the commercial context. And one might finally say this: if one's thinking about licensing, this court has yet to deal with FRAND licenses, fair, reasonable, and non-discriminatory licenses, but it has had to deal with situations where a question arises as to what the right comparable is, and that's something that has vexed the Court of Appeal on occasion. And one of the issues is, well, what are the right comparables to take? What is the ballpark that one should be looking at? And in a context of this kind, one might say, well, commercial inventor employed to produce products and inventions usable across the whole group, very substantial backing from the group in terms of labs and so forth. What ought to be done is that one ought to be looking at, broadly speaking, commercial rates rather than academic rates. So unless you have questions, that's what we have to say on that aspect. May I then deal very briefly with the tax and time value of money points. Tax, first of all, the point is really a very short one, is the approach taken in Celanese, and to some extent supported itself by Gourley, the right approach to take to evaluating what the benefit is. And if I can just do that by going straight to Celanese, which is in volume 11A, at tab 7, E3106. That was a case concerning account of profits. And so the question arose, well, what were the profits that the defendant had made? Because it was those profits and only those profits that should be handed over. And Mr. Justice Laddie, having considered various authorities, including Peter Pan and John and James, concluded that the financial benefit that are made through infringement must be handed over. If the defendant has paid tax on the profits, then subject to the question of what happens if he seeks and obtains a tax credit or repayment, the benefit to him is the sum he retains after tax. And you see that at the top of page 249, and he refers to the authorities in that respect. We have put in our written case the cases where that general approach has been applied, and we respectfully submit that it is the right approach. If I can then invite your attention briefly to Gurley, which is at tab 6 of that bundle. This is a case with which you will all be very familiar. The issue rose in a high-tax environment, claimant injured, claims compensation for the injury, and says, well, I want to have it paid gross of tax, and I'm not going to pay tax on it. Or at least that was assumed. And the court said, well, actually, you can't do it like that. The figures were quite striking in that case because it was a very high-tax environment. It was a rather highly paid employee. And so this was a situation in which the employee would have been, in some senses, much better off financially as a result of having been injured because of the fiscal arrangements than he would have been if he'd been employed. Central point coming out from the judgment of the House of Lords there is reflected on bundle page E3084, where the court says that to ignore the tax element at the present day would be to act in a manner which is out of touch with reality. Lord Goddard, at page 3088, tax is imposed by law. The state exacts a certain proportion of income which varies with the amount of taxable income. So it is treated rightly as something that diminishes the benefit that the, in that case, injured employee has in his hands. Similarly, Lord Reed at E3094, apart from one matter to which I shall refer later, I cannot see why these expenses are any less res inter alios than his payments of income tax in respect of his net earnings. He could not avoid a liability to pay tax, but he might have been able to diminish his outgoings if he'd chosen to spend more time and effort on his work or in travelling in the course of work. In our submission, that is a proposition in general, where Lord Reed later on says he can't find any sufficient reason, theoretical or practical, for excluding the element of tax liability. We commend in this context. The statute has not provided for it, but it might be said that there are reasons of principle why it is desirable to do so. First, the tax is a genuine expense of an undertaking. It's no different in principle from a position where a undertaking, in order to receive a particular benefit, let's say under a contract, has also got then to pay away X% of that contract to someone else to whom that may be due. And to exclude taxation is to inflate the benefit from that which the employer actually received as a benefit. And in principle, one might say that there is no real difference between taxation as paying for inputs, in some sense, to an employer's business. This is perhaps a slightly abstract way of looking at it, but if one thinks about this in the terms of policy that some would say, undertakings flourish in a well-functioning society. That requires roads, education, healthcare, and indeed the ability to on the part of people to buy their products to a degree, which are all contributed to that. Tax is a payment for civilization, and civilization is an input into everyone's life, including businesses. And in those circumstances, it's a cost as well. No one would deny that. It's something that in principle should be taken into account. We respectfully submit that the reasons provided by the Court of Appeal were not sufficient to displace that fundamental approach. The difficulties in calculating the tax to which Lord Justice Patten adverted are actually probably exaggerated in the context of cases of this kind. Because usually in cases of this kind, the starting point is a really successful business where one is going to have a profitability over a considerable period. And so what Dr. Osborne did was he took a slice of the notional income tax over a period, and Mr. Justice Arnold, in our respectful submission, reasonably said, well, actually, that's a perfectly reasonable way of making an appropriate tax adjustment. Secondly, whether it is sufficiently connected to the financial benefit produced by the patents. In our respectful submission, if it's a licensing fee, in a sense, R40 all right, you've got money coming in, you've got to pay a certain amount out. No one would say that VAT that was payable, assuming that it was, and that was not recoverable, was something that was not, in principle, something that one could take into account. So we would respectfully submit that those reasons don't really fully engage with the underlying reasoning of Celanese and the analogy that it provides, and the underlying reasoning of Gurley and the analogy that it provides.
If the employer shares the financial benefit of a patent with the employee, is the employee not taxable on what he receives?
Yes, and that's a separate question, though. This question is only what is the right figure to look at for the benefit that the employer has obtained. And this is actually the mistake that my learned friend's argument makes in relying on Gurley the other way round, which was identified by Mr. Justice Arnold in his decision, where looking at the fact that the employee pays tax is actually neither here nor there, because on this hypothesis, the employee is paying tax on a small percentage of the benefit. And the key argument on this point is, well, what is the benefit upon which the evaluation should then be made?
Yes, income tax wouldn't be relevant to that. It would be
exactly.
It would be the effective rate of corporation tax, which, on your analysis, the group was paying in the years that the cash flow came in, and then presumably averaged or take some sort of median figure for simplicity.
And if I may respectfully say so, that is exactly what happened here. That's exactly what Dr. Osborne did. Yes. And why Mr. Justice Arnold thought, well, actually, that's a rather reasonable thing to do in this context. The third point that we would submit is, if one's thinking about this in the context of accounts of profits, and this is where DOT, the Australian case, it comes in, actually there it's right to attribute what might be called an element of general overhead to the cost of making profits. And there are all sorts of reasons for that. That general proposition was upheld by the High Court in DART, although there was a divergence as to the precise approach that should be taken, the majority taking one approach as to how that should be evaluated, and the minority taking a different approach. But that doesn't affect the general point that we respectfully submit is the right one, that the court should have made the appropriate deduction in this case and looked at the benefit, the net benefit. One might say, what basis is there for not looking at the net benefit net of tax any more than there is a basis for not looking at the net benefit net of any other cost that is incurred in connection with making this revenue.
But you seek to confine our concentration to the benefit to the employer at the moment.
I do, yes.
But fair share could enable you to take account of the impact on the employee of the tax he bears.
Yes, that is potentially the case, just as that's in a sense a corollary of Gourlay.
Well, Gourlay is a different point. Gourlay is looking at the loss. That's what they're trying to calculate for the purposes of the damages. It's not the same point as this.
No, my lady is absolutely right, and one can potentially do that as well. Yes.
Assuming for the sake of the argument that Professor Shanks was entitled to compensation, if Unilever had paid the compensation voluntarily rather than having to be taken to court, they presumably would have paid less corporation tax because they would have they'd have been compelled to share with Professor Shanks the revenue derived from the patent.
Yes.
It would be a business expense.
Yes,
Yeah.
but
And if they're required now by the court to do the same thing, is it not still a business expense?
yes, that's our case. That's our case, is that it's a business expense all the way, but in evaluating what the underlying benefit is, you should also take into account the fact that the whole of the benefit, that there are two sums that one is concerned with here. One is the benefit sum upon which the employee's notional fair share is calculated, and the other is that sum that is paid by the employer to the employee. That smaller sum has, in a sense, a tax consequence on both sides. It may have a tax consequence for the employee, it may have a tax consequence for the employer. But that's not where my argument is focused. My argument is focused on essentially the profits that the tribunal is looking at when it's trying to evaluate this issue. I don't think I can really say any more about it than that. It's a point where you do need to consider whether the principle established in Celanese is appropriately applied here, on the basis that it's not just a principle in Celanese, it's a principle that has high theoretical backing, inter alia, from Gourlay itself. So can I finally turn to the time value of money point? Now, it is possible that this point has actually reduced in scope. Let me just show you how it came in originally, so that you can see why it was potentially a big or bigger issue. If you take up volume 6 again, go to the second report of Mr. Emmanuel, it's at the relevant reference is E1738, so it's paragraph 1312 or page 39 of that report. The case that we were faced with at the tribunal, advanced by my learned friend with the assistance of Mr. Emmanuel, was that the right benefit to take on the basis of his evaluation of the net present value of the gross benefit having been inflated in the way that he suggested, having sought to take particular percentages that were used in a completely different context over here, was 100 million or over 100 million pounds, and because the university share was advanced, partly on the basis that it ought to be even higher, the claim that was advanced was for, as Mr. Emmanuel said on the next page, 1313, using two approaches to the rates of return, I arrived at estimates of fair shares ranging from over 25 million to over 37 million in 2012 values. And he says it's not an accurate science. Well, we'd certainly agree with that. And he said that his analysis drove him to this range in that context. Now, if one does an analysis that requires the time value of money to be taken into account, in evaluation of what the benefit was. That is the kind of approach that people are driven to. And in fact, one can see the undesirability of it, because if you make slight adjustments to the percentages in relation to the discount rate that you take, you have absolutely wildly fluctuating figures at the end of the day. And what was said was, well, the right analogy is between Sempra and compound interest for money had and received. And I don't need to develop that argument before this court. That's gone. That's gone. In our submission, that point is simply wrong. And in fact, if one looks at the way that the Court of Appeal decided it, it may actually be now really common ground that is, or it is common ground in the Court of Appeal. That's not the right approach. If you would be good enough just to turn to the Court of Appeal's decision, Bundle 1 6A, E 173, Lord Justice Briggs, who deals with the time value of money with which Lord Justice Sales, as he then was, agrees in a short judgment. He says that he agrees that where, as it usually will, the analysis and quantification of benefit of the invention to the employer depends either totally or partly upon the money received from its exploitation, the inquiry is usually to be directed to the amounts actually received at the time they were received, and that the use to which the employer subsequently put those receipts should not be taken into account. Those, of course, familiar with the prudential line would say, well, that sounds familiar from a different context. And the reason why that is, in a sense, so right, or perhaps even more right than in the prudential context, is that this is not money which is wrongly held by the employer. Until a claim that is made, it is rightly held. And indeed, on anyone's case, a very substantial chunk of that, well, actually not anyone's case, because on Mr. Emanuel's case, no part of that, at least in monetary terms, should be retained by Unilever, should have been retained by Unilever. But on any reasonable case, a substantial chunk is Unilever's on any view, because the statute provides that certainly Unilever is entitled to a share. And so the idea that one looks for the purposes of benefit at this kind of analysis is just, we would respectfully submit, misconceived.
Well, it's not so much looking at it in quantifying the benefit, it's rather deciding what a fair share of.
Yes, and but that's not how the matter was put. The matter was not put in that way. What it was put is you need to look at the benefit, quantify the benefit in that way. That was how the case was run before the hearing officer.
No, but what we have to consider,
you have to consider is a slightly different.
Is whether Lord Briggs is correct at paragraph 73.
That's right.
Where he is used as the peg, the fair share, and the reality, not of what Unilever did with the money, but the attrition that time and RPI or CPI is caused to its value.
Two short points in relation to that. First of all, this is not a jurisdiction where there is provision for payment of interest. We say, actually, that's not surprising. If you are tempted by that line, and you're tempted to say, well, actually, there are circumstances where the employee will suffer unjustly by being kept out of his share, then actually that is something that needs to be done on the basis of proper evidence that the employee has, in a sense, been unjustly kept out of his share. And that brings in issues on whether or not the employee himself or herself was guilty of delaying in bringing the claim, in bringing the matter to court and so forth, as we say was the case here. What one can't do is simply say, well, because there is no provision for interest, what we're going to do is we're going to inflate the value of the claim that otherwise would be inflated. Bringing matters in by the back door in every case. And we would respectfully submit that if that is the approach that is adopted, that is too sweeping an approach for this jurisdiction.
The other option, rather than inflating the value of the claim, would be to increase the percentage of the fair share to take account of the lost value in money, and there one could have regard to delay and various other things if they were relevant.
If and insofar as that was the approach taken, then I suspect there wouldn't be a great deal that one would argue about in inappropriate cases. But that would require some investigation as to whether that was the appropriate course, because otherwise what one is doing is actually bringing in a statutory interest system, effectively, in circumstances where that is not provided. And it might be said that one also then needs a little bit of clarity, which it may be said would benefit, this approach would benefit from, where Lord Justice Briggs said the order for payment if some interest or inflation adjustment is not included within the award. Well, interest and inflation are not always the same things. Perhaps there is some analogy in some contexts. There isn't always. But in our respectful submission, there does need to be an element of clarity as to the circumstances in which a employee would be entitled to say, I should have a greater share, and if so, what, to take account of those matters. And that is something that you'll need to consider.
Yes, I can see that there's a big difference between an interest element and an inflation adjustment.
Unless I can assist you further, those are our submissions.
It would appear not, Mr. Alexander. Thank you very much indeed. Mr. Hill? Mr. Green?
Ladieships and Lordships, can I take those last 2 points first and respond to tax and time value of money in that order? The learned friend took the court first to Celanese to demonstrate what he called the Celanese principle, and that's in volume 11A at tab 7, and in particular at page E3107. And whilst it's right that my learned friend passed over this passage, the significance of what was actually said by Mr. Justice Laddie may not have been highlighted fully to the court. What Mr. Justice Laddie says there at the top of that page, E3107, second line, if the defendant has paid tax on the profits, then, and then possibly the rather important phrase, which I think my Lord Reed's question may have been inspired by, subject to the question of what happens if he seeks and obtains a tax credit or repayment, the benefit to him is the sum he retains after tax. Mm-hmm. So if we're going to apply that principle, there are two extremely good reasons why the benefit should not have tax deducted. One is, my learned friend's just conceded that point, and the other is that I asked Dr. Osborne about it during the trial, and I said, if they pay a share to Professor Shanks, they'll get the tax back in respect of that, and he said yes. Yeah. So the first point is a simple one, which is that if you take the Celanese principle, my learned friend's position with respect is completely unarguable, and was conceded by his own expert called on the tax point before the hearing officer. So criticise the hearing officer for getting it wrong seems a little unfair. The second...
I mean, say, for example, for the sake of argument, say one thought that a fair share would be 1/3 to Professor Shanks, 2/3 to Unilever.
Precisely.
And they pay him 1/3 of the net amount, and then they reclaim the tax, having set entered that as a business expense in their accounts, they end up actually with more than two-thirds of the gross amount.
Exactly. It's a way of getting back some of what you've paid. So it's demonstrably wrong, both on the maths, logic, and in principle, and on the basis of the concession of their own expert and learned friend.
Could you please give us the reference to the concession by the expert?
Yes, the concession by the expert is at E 1892 to 3, line 24.
E1892.
7 tab 53 at 789. I'm grateful to Ms Campbell for directing me to the right page in my notes for that. So that's a short point. And then there's a sort of second layer, if one goes sort of off-piece, as it were, and looks at the Gourley approach. And I take my Lady Black's point about that, which is dealing with a different thing. But this is my secondary argument, which I think we don't even get to. But even if we do, it's still wrong, because the Stoke-on-Trent Authority, which is, I found immediately when I looked up the Gourley point, Stoke-on-Trent says where the burden of proof lies in respect to that. So that's in volume 11B at tab 19, and we find that at page E3376. And this is really the point on the application of Gourley. And the basis of the decision was justice. It's down at letter H. And what the court says there is, but before we do so, we think it necessary to draw attention to one important distinction between West Suffolk County Council and the present case. In West Suffolk, as already pointed out, the Inland Revenue had made plain that in their view, no income tax was chargeable on the compensation in question, and the House of Lords proceeded on the assumption that that view was correct. In the present case, the Inland Revenue have written no such letter, nor given any assurance. On the contrary, the exchange of letters between the claimants and one department of the Inland Revenue suggested they would, or at least might, seek to contend that corporation capital gains tax was payable. And the relevant point we get at just below C, we regard the position of the Inland Revenue in this case as of importance. If hereafter an attempt is made by the Inland Revenue to levy tax in one form or another upon that sum in the hands of the claimants, and that attempt ultimately succeeded, after we in this court had held, reversing the Lands Tribunal, that some lesser sum were payable by the acquiring authority because of the application of West Suffolk, a grave injustice would have been done to the claimants. They would have received a lesser amount from the acquiring authority on the basis that that which they received would not be taxable, and yet they would or might thereafter have to pay tax at the instance of the Inland Revenue on that lesser amount. And the passage between E and F in fact, down at H is the summary, then it seems to us unjust that in a doubtful situation the acquiring authority can get the benefit of a reduced payment while leaving the claimants exposed to the risk we have mentioned. That is the passage between E and H, which is cited in the textbooks as saying the burden of proof is on the person who seeks to say that the claimant will definitely have to pay tax. So it's not only where the claimant definitely won't pay tax, not only where the claimant will definitely pay tax, but where it's in doubt. And the short point is, on that second layer, there was no evidence about the claimant's liability to tax put forward by the respondent to make out their case on this footing. So they doubly lost in our respectful submission. So that's a short point in relation to tax. We also say that it just doesn't fit with the overall scheme provisions, and particularly the words that say to secure a fair share for the employee. And my Lord Reed's arithmetical point immediately comes to mind in relation to that. So that's a short point on that. In relation to time value, the peculiarity in a sense is that the High Court on transfer does have the ability to award interest, but the controller doesn't. Was it really the Labour government in 1970s idea that whether or not the passage of time could be reflected would depend on the controller's view as to whether it was a complicated case. Obviously wrong, we respectfully say, and it doesn't fit with the overall scheme of the provisions, which is to secure for the employee a fair share of the benefit, and that involves, sensibly, taking account of the passage of time for the reasons given by the majority in the Court of Appeal. But there's a further point about that. The structure of these statutory provisions is unusual because they allow the making of an application at any time. So one doesn't have a normal 6-year limitation period after leaving employment or something of that sort. And that's because the employer holds all the cards. The employer knows what their licensing deals they've done, and they're often confidential, as reflected in an order that the Unilever companies invited this court to make about confidentiality. So the employee holds none of the cards, and the effect of a learned friend submission is that provisions which were designed to ensure fairness, if outcome, can be manipulated by an employer by concealment, such that there may be a great delay in the employee's ability to obtain the necessary evidence, or even to know that he has a claim, or that she should have brought a claim, and that cannot be catered for or recognised in an award that the court should make. It cannot be right.
Do proceedings of this kind have to be brought before the controller?
My Lord, the way it works, I'm sorry, I should have explained. I mentioned it in passing. It has to be brought before the controller, but the controller can refer it to the Patents Court.
And then what will be the jurisdiction of the Patents Court to grant interest?
The Patents Court, it's been accepted throughout, has the power to grant interest. So it's just, we respectfully say it's obviously wrong. And I possibly made a rather broad brush submission about the merits of it to the Court of Appeal, simply saying we're agnostic about where you bring it in, reflecting time value, because obviously time value is not going to make a benefit. It's not outstanding, otherwise outstanding. We're agnostic about where you bring it in, but it's got to be taken account of when an award is made in result.
So your submission is that in the Patent Office, the court should, as a matter of course, exercise its discretion to award the time value?
And my Lord, no. All we respectfully say is that when you seek to give an award in accordance with the statute that says it should secure for the employee a fair share, and those words are quite striking, that necessarily means giving conscientious thought to what today will secure for the employee a fair share of what the employer has received.
Which could well be upping the percentage rather than
how one does
pretending the benefit was something other than what it was. Yeah.
Precisely. Yes. The mechanics, in a sense, are secondary, subject, of course, complying with the provisions. But we say it's obviously fair and it's obviously right.
Do you know on what basis the Patent Court awards interest?
I was wondering that.
Yeah. It's not a liquid debt.
More an expert in that court than I am. I'm a rather humble practitioner, but.
Well, the Interest on Damages Act wouldn't apply because it's not damages, and it's not a liquid debt that's owing either.
It may be... My Lord, I don't know the answer to the question, simply because we proceeded on the basis that there was that anomaly below, and no one challenged it. But the short point is that even without that anomaly, we respectfully say that the answer is injustice right, and that's given the specific provisions of the Patents Act.
Well, for my part, I would welcome assistance on this question of whether or not the Patent Court would have the power to award interest
My Lord,
in a case of this kind, were it referred up by the Patent Office.
My Lord, yes.
And also the provision which requires you to institute proceedings in the Patent Office, but confer the office has the power to refer it up.
Yes, I think it's in, from memory, it may be in 11A. Because if we look at, I think it's in, I think it may be on E3038 from memory.
Pardon me.
Oh, sorry. It's on 3036. There's at 40 subparagraph 5.
Yes.
That is the reference up to the Patents Court. And
Well, is it?
that's
he
where...
declines to deal with it. Does that mean it's referred up, or does that mean it institutes proceedings in the High Court?
My Lord, I had understood it means it's been referred up by him, and I think we got that from the CIPA handbook originally. But perhaps my learned friend and I can just try and agree a very short one-page note to assist the court on A, what the precise route is and which provisions they are, and B, what the jurisdiction for interest would be, if that would assist the court.
Certainly I would welcome that for my part.
I think we all would.
Yes, yes.
I'm most grateful. So those are the key points in relation to tax and time value. We have provided the court with the up-to-date, as we promised in our written case, just the Bank of England standard calculator of what the value is today. And that's now 41.367 million.
41.367.
Just because my learned friend did some colourful island hopping in relation to the way it was put below, it might be worth the court noting that Mr. Emmanuel in that passage, where he was applying NPV values, was adopting an approach which he'd identified Dr. Osborne as having adopted in terms of devaluing matters. So Mr. Emmanuel, Dr. Osborne took 10% and 16%, and that was Mr. Emmanuel responding in turn to that. So may I now turn to some brief points in response to my learned friend. The first point is this question of significance. And my learned friend has, in our respectful submission, done something which is not permissible or available to him, which is repeatedly to assert to the court that the sums in issue were not significant to Unilever. And it's been done this morning. It was done yesterday. And versions of it are found in the written case at paragraph 98, which is at E76, and paragraph 119 at E85. And the reason why I respectfully say that is because they had two main thrusts below, apart from challenging whether Professor Shanks actually invented very much at all. The respondents submitted that first, this was not a significant sum to Unilever, and secondly, this was the run-of-the-mill return. And they lost on both of those points. So it's wrong for this court's consideration of this benefit to start from the fact that this was not significant. And I did invite the court briefly to look at that in the hearing officer's decision before, but it's easy to see it in the conclusion at page E419, paragraphs 222 and 223. So considering the 222 on page E419, considering the totality of the evidence, I was left with a clear impression. The benefit provided by the Shanks patents was a substantial and significant one in money terms, the sort of sum Unilever, by which he means the whole group, would on the evidence worry about. And he refers to Project Hyacinth. It's not open to my learned friend to improve the result that he got from the hearing officer by reference to an argument on which he lost. And then he goes on to say, further, in comparison to the benefit from other patents to Unilever, from the evidence before me, it does, in Mr. Emmanuel's words, stand out. Pausing there. That is a reference, or certainly relates to, what one of the questions that my Lord Kitchen asked learned friend yesterday, which was whether the right approach was to consider what would have been obtained from other patents. And my Lord said, may I put another point to you in relation to little paragraph 4 of Kelly at paragraph 60? Mr. Justice Floyd says, the benefit must be something more than one would normally expect to arise from the duties which the employee is paid. Do I understand your submission that one should look at what your submission to be, that one should look at it in terms of what one would normally expect to arise from a patent? Answer, yes. Made or arising from for the duties for which the employee is paid? Question mark. Yes, absolutely, because if one is considering particularly an employee in industry who is in some senses employed to make patented inventions for his employer or his or her employer, the expectation from that is that the employee, and particularly the employee in a substantial undertaking, employed to do work for the whole undertaking, will expect to deliver things that are of benefit for that undertaking, certainly. That's the very job for which they're paid, is to deliver patents that are of benefit to the undertaking. Now, taking Kelly, paragraph 60, little 4, my learned friend's acceptance of the point that my Lord Kitchen put to him, if you're going to compare it with what they should expect from patents, if that's the right approach, what happened before the hearing officer was that Unilever ran a case that generally on patents, this was run of the mill, and that case, with respect, was rejected. And my learned friend, in his written case, at paragraph 114D, paragraph 80, page E83, he fairly recognises, and we respectfully say correctly recognises, that in subparagraph D, second line, Dr. Mulder's evidence attempted to estimate benefit without going through the laborious and disproportionate exercise in Kelly. That attempt was rejected. And that's right. And what in fact happened in cross-examination, I can give the court the references to the transcript if it's helpful. What in fact happened was Dr. Mulder appreciated the shortcomings of the document he'd produced and tried to say, well, I'm not trying to give an indication of financial value. And I then sought to cross-examine him on the fact that what he was doing was appreciating the shortcomings of it and trying to back off from what his own witness statement said at paragraphs 14 and 15, that he was trying to give an impression of financial value. So that is the backdrop to which the shortcomings of the Mulder analysis were rejected, as my learned friend accepted they were, by the hearing officer. And that's the context in which the hearing officer, back in his decision at E419, reached the conclusion at 222 that in comparison to the benefit from other patents to Unilever, from the evidence before me, and he specifically pressed my learned friend in closing to direct him to what evidence he should look at about that, in Mr. Manuel's words, it does stand out. We respectfully say, on the test put forward by my Lord Kitchen yesterday, accepted by my learned friend, that is actually determinative of it being sufficiently out of the ordinary and outstanding, we respectfully say. But we don't rest on that point, because by any metric, it was outstanding. My learned friend invited the court to consider paragraph 219 at the top of that page, and said Dr. Mulder in his evidence, and a party was not challenged on, identified a number of highly successful products manufactured by Unilever, including Viennetta ice cream, spreads and deodorants. He referred to incomes of many billions of pounds, in general terms, over the lifetime of the patents protecting the products, with profits over the same period of at least hundreds of millions. I believe this gives some indication of the sorts of benefits generated by highly successful products. He doesn't make a finding that they're attributable to the patents, and so the sorts of sums that can be considered of great benefit to Unilever, which are of an order of magnitude greater than the benefit in this case. That's in circumstances where at 207, he has expressly warned himself not to simply look at overall turnover or profits of an employer's undertaking and simply state the given benefit is a small percentage of that. And that is what he appears precisely to do at paragraph 223. He says, taking account of the size and nature of Unilever's business, the benefit provided by the Shanks patents falls short of being outstanding, and that's referable to those lines, those 3 lines in 222, where he says, but Unilever makes profits at an order of magnitude greater on other inventions, the foundation for which is unclear, albeit primarily by manufacture and a much lower rate of return than was provided by the Shanks patents. Now, pausing there, my learned friend also identified for the court the relevant profit and turnover figures. And just taking the figures for 1984, the turnover was £16 billion. This is the year of the priority application. And the profit was £925 million. So the profit was 5.78%. Which means that when Unilever spends £16.30, it makes £1. The finding in relation to this is that it spent, over the entire life of the patents, £250,000 and received approximately 100 times that amount. That is 1,600 times better than the rest of their business, on average. 1,600 times better, or if you multiply that by 100, that percentage. And this is in circumstances where all of those employees are said by my learned friend to enjoy the same advantages of leverage within Unilever as Professor Shanks is said to have enjoyed. And yet, the difference in the rate of return and the actual arithmetic is striking. Moreover, I referred in opening to an error of arithmetic at paragraph 220. And the court can now see, with the benefit of those figures, that indeed the hearing officer was one entire order of magnitude out in his assessment at paragraph 220. Because what he says is profits of hundreds of millions on revenues of billions necessarily implies expenditure in the hundreds of millions.
So this is your mathematical point that you made in your last speech.
My Lord, yes. Yes. The only point is it's writ very large when you look at the real figures. Because it's 16 times the sum to achieve a pound, 16.3 times to achieve £1 of profit.
Where is the finding that £250,000 is the right figure?
That's that's paragraph 183 at 412.
Thanks.
And that follows the submission at 180.
Yeah.
That, in a sense, there weren't any invention costs. And the point about that is that this is a really striking case because Malone and Friends emphasised the importance of Professor Shanks being within Unilever in general. But in fact, in this case, there are two very salient points. And I'll make them briefly because I already made them yesterday. The first is the way in which the invention was made. And there being absolutely no suggestion that he didn't completely fulfil all the contractual duties and matters he was otherwise working. For example, the tin oxide electrodes that found expression in the priority application were because that's what he still had left at home from his previous job. His daughter's chemistry kit, the two little mylar plates. And my ladies, my lords, the reason I say that's of particular significance is we finally got the bank's report, the relevant parts of the bank's report. And I've got to say, I'm thrilled and surprised, and I'm most grateful to my lady for asking for it, because for the last, I think, 12 years, I have been saying in open court repeatedly, we've been unable to find it. And those instructing me have requested Kew, the National Archive, to provide it, and they've sent us an email. We've sought various documents from different sources. The standing committee we couldn't get from the National Archive.
Brilliant. We've got it now.
We've got it now. I'm most grateful. But it is extremely instructive. And it does bear on this point, which my Lord Kitchen asked me about, which was what's the relevance of how it's invented? Because actually it's of central relevance, we respectfully say, particularly when you look at what the bank's report actually said. And the overview of the bank's report is to set out the law at 440, and consider the circumstances in which something might be owned by an employee at 442, in the middle of 442, paragraph 442 on page 132, just below the Fine Industrial Commodities Limited and Powling case. And then, over at 444, it's extremely interesting. It says, in some cases, it will be relatively easy to decide that the employee is entitled to all rights in his own invention. The person employed to sweep the factory floor, who, as a result of his observations while carrying out his duties, invents an improvement to one of his employer's machines, will almost certainly be so entitled. An employee employed as a research and development engineer who makes an invention which it was his duty to make will almost as certainly hold such an invention as trustee for his employer. On the other hand, this is a middle point, a research and development engineer who makes an invention which it was not part of his duty to make may well be entitled to the benefits of that invention. And then 445, between these fairly clear-cut situations, fall a variety of cases, and these are where the real difficulties arise. The research and development engineer might have made an invention in his own time, but nevertheless connected with his employer's business. Alternatively, he might have used some of his employer's materials and some of his employer's time to make an invention totally unconnected with the employer's business. And then some examples are given. And then Section 56 of the Act is considered, of the 49 Act is considered, which I confess I was unaware of, where the idea was that there could be circumstances in which the binary division between what we have in 39(1)A and 39(1)B might not be completely fair. And it said, Section 56 of the Patents Act was introduced in the 1949 Act as a result of two recommendations made by the Swan Committee. The first recommendation was it should be possible for controllers to hear disputes between employer and employee over ownership. This recommendation was embodied in 56(1), which also provided the controller may refuse to exercise his powers if it better exercised by the court. And that facility for hearing for the controller has not been much used, only 35 applications. And then 447, the Swan Committee further thought that the common law position under which the invention has to belong either to the employer or to the employee could result in injustice, since there might well be circumstances under which fairness demanded that both should be entitled to a share in the benefits from the invention. The committee suggested that where there was no contract, there should be provision for apportioning the benefit in cases which came within two extremes recognised by the common law. And those are the categories we now see, of course, in 39(1)A and 39(1)B. Section 56(2) provides the court or controller may, unless satisfied that one or other parties is entitled to exclusion of the other to the benefit of the invention made by the employee, apportion the benefit between them. It's been considered in the courts in only one case, in Patchett and Sterling case referred to above, the House of Lords decided that in the absence of contractual provisions to the contrary, an invention belonged absolutely either to the employer or to the employee, and 56(2) did not make any changes in this basic provision. This construction of 56(2) has made it virtually a dead letter. Probably it gives a power to apportion only where the parties have agreed to divide it. And then you see in 1965 the government attempted to restore the provision to what it was believed to be before Patchett and Sterling by the introduction of Employers' Inventions Bill, but that was met with difficulties and finally withdrawn. So the genesis of the concern is in perhaps particularly these middle ground inventions. So when my Lord Kitchen asked me what's the relevance of how it was invented, I would now strongly rely on the fact that there was a legislative provision designed to cater for a situation where the benefit might be shared on the unusual and particular facts of this very case. The conclusion of the Banks Committee was that it was a very good idea for there to be such incentives for employee inventors, but that it'd be better to encourage voluntary schemes rather than to legislate. Parliament took a different view. So it's not the first time that a provision of this sort has risked becoming a dead letter. May I now just go back against that background to looking at the relative importance of Unilever's failure to show any patents of similar value. And we respectfully say an error that the hearing officer made at paragraph 218 in that respect. Because his view was it was essentially a ratchet point which could only assist Unilever if they were right, but if Professor Shanks was right, it couldn't assist him. And we respectfully say that's not right, particularly on the footing of paragraph 64 of Kelly and the submission made by my learned friend in answer to Lord Kitchen's question yesterday. He says at 218, on E418, 4 lines down, had Dr. Mulder's efforts to disaggregate the benefits from patents shown convincingly that other patents were more beneficial than the Shanks patents, that might have pointed away from the Shanks patents, providing outstanding benefit. Dr. Mulder's failure to do that does not, I think, indicate anything one way or the other. Well, we respectfully say that's not right. If you run a case that something's entirely run-of-the-mill, but you can't produce a single example, not even one, to show anything of the same order of magnitude, we respectfully say that is significant because it defeats the allegation or undermines the allegation very, very substantially that this can be sensibly described as run-of-the-mill in the way that Unilever claimed it could be. I gave the court the references to the case, the run-of-the-mill point, in the opening and closing skeleton arguments before the IPO yesterday, and the passage where Malone and Friend was pressed on whether there was any specific evidence to show it was run-of-the-mill in the closing submissions was at volume 9, tab 60, pages 58 to 61, starting at E2588, and particularly at E2590. In response to which, Malone and Friend says, well, it's completely unreasonable to require employers to do a Kelly-like exercise. Well, I'm afraid it is a consequence of two things that may have to be done, at least with one example, in certain circumstances. Employees, unless it's a bare licensing case like this, always face that challenge. And many of them have failed to meet it and lost their cases as a result. The idea that it's unfair on the employer to require them to do that too does not seem to be a fair objection to the operation of the statute as crafted by Parliament, which requires reference to the benefit of the patent to be identified and then a qualitative assessment of whether or not it's out of the ordinary. But it also depends on whether the employer chooses to run the defence, this is completely run-of-the-mill. Because they ran the argument, they ran two arguments, this is not significant sum for Unilever, which they lost on, and they also ran, it's completely run-of-the-mill, and lost on that as well. So the obligation on the employer to do some sort of Kelly estimate that's meaningful follows from a decision by the employer to run a defence that it's entirely run-of-the-mill with other patents. It's at the point that Malone and Friend says that, well, in no particular year did this bring in a sum more than 1% of Unilever's profits. Well, whether or not Unilever had 200,000 or 300,000 employees at the time, globally, for those profits to be generated, one employee generating close to 1% of a profit in 1 year is absolutely astonishing on a per employee basis. So by any rational metrics, again, this is completely outstanding. The particular facts of Professor Shanks' situation emphasised that because what he did didn't fit with anywhere within Unilever. It was an orphan technology. That was a phrase first used by the respondent in their original counterstatement at paragraphs 19.1 and 30 at E2722 and 2729. And there was a culture within Unilever about which the hearing officers made primary findings that were extremely unhelpful to him, and he encountered a strong headwind from drafting rather a better patent from Mr. Stancliffe and mentioning blood glucose testing within it. So the individual leverage point of being better off in a large company on the evidence before the hearing officer was, we respectfully say, extremely doubtful, or on the hearing officer's own findings, negative in some senses. And that is twinned with the hearing officer's express findings that Unilever did not have the sort of licensing expertise that one would expect from a skilled and dedicated licensing team. So despite its gigantic size, it didn't have the relevant expertise to this exploitation task that one might have expected from a reasonably sized SME, let alone from a very large company like Unilever. And the difficulty that Professor Shanks faces here is that he's effectively responding to an attempt to reopen findings about how Unilever went about the exploitation, when actually there must have been a collective sigh of relief at Unilever when the hearing officer spared their blushes largely by making quite gentle findings about some of the many delays of many months, failures to sign up company A, failure to respond to the Italian company for 4.5 months, and so forth. And then
we can't go behind his gentle findings, then.
So,
we can't go behind his so-called gentle findings.
well, my lord, that's rather the point. They are indicative that you can have muscle, but you may not be deploying it to its best effect.
And I should gently warn you that you've only got a couple of minutes left.
My lady, I've seen that. I'm most grateful. My lady, just in relation to the point my learned friend sought to make in answer to the question about, I think my Lord Hodges' question about paragraph 207 on E416, learned friend suggests that wasn't about licensing leverage. That's completely wrong for two reasons. Fourth line down, different undertakings, not individuals, will have different leverage. And over the page at the top of 417, you'll see the phrase, to get from licensing its patents. He was specifically considering that. So with respect, my learned friend is wrong.
Yes, it would be unlikely if he considered it there that it had slipped his mind when he got on to fair share.
Well, it was the only thing they had. So we respectfully say, in summary, the identification of the undertaking, the correct identification of the undertaking is an important first step. It can't go outside the employer's assets and business, but it's fair to have regard to what the nature and size of that undertaking is. But that's not to say that the hearing officer having disavowed taking an arbitrarily small undertaking, he can take an arbitrarily large one. It's having disavowed saying that he would not disavowed a simple arithmetical comparison, he then adopted one. We don't say that's the right approach. We respectfully say that the undertaking has to have some functional connection to the area of work in which the person concerned was working, if the analysis is not to be a prisoner to the way the respondent employer has chosen to structure its business as a whole. The very anomaly which was said to justify departing from the statute. We also say that on any view, this extraordinary accomplishment of Professor Shanks's did deliver a benefit that was clearly out of the ordinary and was outstanding on any basis by any measure, except perhaps by the one finally chosen, which was just to say, well, global profits overall are very, very large. Unless I can assist the court further.
Would appear not. Thank you very much, Mr. Green. Thank you. Mr. Alexander.
Just a few points on tax and the time value of money. Let me deal with tax first of all. First of all, it was suggested that this point was conceded either by us or by our expert. That's just not right. What you need to do is to read the cross-examination in full, because what was put to Dr. Osborne, quite rightly, was that on corporation tax, if Unilever were to pay out a particular sum to Professor Shanks, then that was a cost of doing business and it would reclaim corporation tax. And he, of course, agreed with that, which is perfectly obvious. But he then but then it was put to him, why would you reduce the corporation tax, the figure that we are concerned with? And he said, the reason for doing it was not to get a figure that you are concerned with, because his reason for reducing the figure by corporation tax is the benefit that Unilever obtained, not the fair share that Unilever would pay out. And it's very important to keep those two distinct. Of course, one can think of arithmetical situations, of which one example was given, where you have a third payout or a half a payout, which, depending on the respective recovery entitlements of corporation tax, may result in an anomalous situation. But let us take a situation where there is where the bulk of the benefit is retained by the employer. In those circumstances, one has to, if one's following at least the Celanese and we would say Gurley principle, look at what the benefit is in net terms to the employer. It may well be that there is a payment out in these circumstances of a fraction of that to the employee, on which the employee would have to pay tax or not, and the employer may be able to recover tax. But that is a completely separate question to whether or not it is right to look at the benefit gross or net of tax. And this is an issue with which you will have to grapple and essentially decide.
Well, the point I was making didn't depend in the least on the figures. You could do
it doesn't.
You could do it algebraically.
Absolutely. Absolutely. And my point there is only this, that there are some figures where one could potentially result in an anomaly, which my Lord was, I think, referring to, but there are others where it wouldn't. And in any event, what one would simply do is to say, well, actually, that's just a consequence of the tax system. You can recover on expenses.
Well, the simple point is that if you take the benefit net, the result is the employer, as it were, has his cake and eats it, because he's able, when he claims the payment that he makes to the employee as a business expense, to reclaim if you assume constant tax rates, he reclaims exactly the tax that was paid on that proportion of the benefit. Obviously, if tax rates change, the proportion will change.
Your Lordship is absolutely right, but there is an important point that your Lordship makes, which is on the proportion. What he doesn't reclaim, and is never able to reclaim on that basis, is the tax that he must pay on the proportion that he retains.
Yes.
And it is that is an issue in this context. And that's why, in the context of account of profits, one looks at the matter net of tax, because what one is considering is the benefit that is retained by the defendant in order to determine what it is that the defendant should disgorge, just as one considers a benefit net of other expenses that a defendant has to pay with respect to that particular benefit. If a defendant has to pay, for example, in the context of a account of profits, license fees to third parties for the right to make that invention, then to that extent, the defendant has not made those profits. If the defendant has to pay employees or whatever general overheads or specific overheads or raw materials, to that extent the defendant has not made those profits. That is the point that comes out of Celanese. And if a defendant in this kind of situation has had to pay tax, to that extent it has not had the benefit. And your Lordship is of course right to say that there is an opportunity for an employer to recover that proportion, but that's a different point. The Stoke-on-Trent point, that we respectfully submit, has no application here at all. Here there was specific evidence, and not countered by any other evidence, as to the corporation tax that was payable in the relevant periods. That's why Mr. Justice Arnold was able to make a finding in relation to it. And there was evidence in our experts' evidence who did an analysis. There was no dispute that those were the corporation tax rates at the relevant point. And so this was as much a liability that Unilever had to pay out in relation to what it recovered as any other liability. In relation to the time value of money point, we had probably better do a short note on powers relating to interest, because that's really the point that was, I detect, troubling.
Well, Mr. Green suggested you attempt to agree a joint note on this subject.
We will do that.
I'm not optimistic.
What we might try and do is just do something on what the statutory provisions are, and then that will be fine.
Let them speak for themselves.
Let them speak for themselves. Yes. The only question that then remains to the court is this. One of the issues one might say is, well, if one's thinking about interest, and this follows on from a question raised, usually one knows exactly what the date is from which interest is payable, because there's a date on which a debt is due or a particular liability becomes due in this kind of context. This is a very unusual jurisdiction in that what you have is a right to make a claim for a proportion. The employer doesn't have an obligation that arises before a claim is intimated or...
because nothing is wrongfully withheld.
Because nothing is wrongfully withheld. This is, in a sense, what I call the superprudential point for the non-time value of money.
It has to be triggered by a claim.
It has to be triggered. So then one actually thinks, well, what is the right starting point if one's actually thinking about this, both as a matter of inflator and as a matter of strict liability to pay interest? So even if there is a possibility of awarding interest, that doesn't, unfortunately, absolve this court of considering what it should say, if anything, about the circumstances in which, and from which date, and by which tribunal, if a tribunal, it should be paid. In this case, of course, one needs to be a little bit careful as well, because the claimant here elected to bring proceedings in a tribunal where no interest was payable, after, we say, a very long period of delay. There was never a suggestion that there should be a transfer, even on a costs-limited basis, as there sometimes is to the Intellectual Property Enterprise Court, where the same costs regime is maintained, in order to maintain that right. And the reason is that that's not really the case they were advancing at all. They were advancing a case not that interest should be paid, but that the basic sum should be inflated by these time value of money claims to get you to 100 million, and then apply their 33 or whatever percent to that. So if one is looking at the whole picture here, and one wants to do a evaluation of what then an employer is supposed to do to take account of that, where an employee has specifically chosen a forum where interest is not payable, but then later on comes along after an argument has been rejected that time value of money should be taken into account with respect to the benefit, says, oh, well, nonetheless, what you should do is go round the back door and treat this tribunal as one in which interest is awardable from query what date, and as a result, inflate a claim which otherwise had no interest. Now, we respectfully submit that gives rise to some real questions of fairness, particularly in the context of a discretionary jurisdiction. Because you might say, well, all right, if we're going down that route, then we need to look at what all the circumstances are, what the right date is, what the right notional rate of interest is, and so forth. We don't accept the approach is right simply to hand up a CPI calculation on the basis of what appears to be a 1999 date and say, well, right, we're going to take the inflator of, in that context, of the benefit and then invite this sum to be applied there. That would not be an appropriate approach. It would lead to great uncertainty for those seeking to resolve matters, and would be unfair because it would not make it possible for people to predict even. In a sense, contrary to Kelly, where there wasn't this issue, because the beauty of Kelly, in a way, was that it was nice round figures, payable to the two outstanding employees. Everyone, in a sense, could operate on that simple basis, albeit there we would say that the tax ought to have been taken into account. But if this court is going to, in a sense, for the first time, set strict legal parameters or a approach to the exercise of a discretion either with respect to CPI or interest, and if so, on what basis, that is something that requires, in our submission, careful thought. It may also have repercussions for other jurisdictions where no interest is awardable, but where it is said, well, precisely because no interest is awardable, we're going to award interest. There's no question of concealment here, I should say. If that was suggested, I don't think it is, but if it is, that would raise a set of other issues.
Mr. Alexander, could you just help me? The figure that you've given us of the relevant sum, taking into account the time value of money, what is the date from which that is calculated, and why was that chosen?
My Lord, it's actually my figure.
Beg your pardon.
It's on E45 in the skeleton paragraph 118. That's the median year in which the sums were received.
Thank you very much.
I don't think I can assist you further at this stage. If you wish to have written submissions on more substantial points, perhaps that might be indicated in relation to the interest point. Otherwise, we will just provide you with the statutory provisions.
I would have thought so. Just want to know what the position is.
Yes.
And on how the cases get from the controller to...
Yeah.
Yes, we'll certainly do that.
Yep. Good. Well, thank you all very much indeed. Most enjoyable day and a half. It'll be less enjoyable from now on. Court will now adjourn.